but someone already posted something and you know you are stealing that post. You know that you are stealing that post, and that person came to know about using that particular post by you, then he can send a legal notice to you. Teach the students the fundamental rights like Article 19 of the Constitution. First, they have to know about what are their rights. What is the Constitution guarantees to them? The freedom of speech and expression, along with reasonable restriction. Now, legal mandatory, every apps, every software, they have to give this information. What kind of information they are taking from you, from your phones. So we have to make sure our children, our students, they must be aware about these digital platforms. So just imagine that you are a journalist and you recently attended a legislative assembly session and you faithfully report what you have witnessed in the house. And the next morning, the media you are associating with actually published whatever you witnessed in the house. So you are expecting some kind of appreciation from the public because you informed what actually going on the legislative assembly. But instead of this appreciation, suppose just imagine you are getting a legal notice and someone initiated legal action against you. What would be your response? So should a journalist be punished for reporting what elected representatives say in the house? This is not a hypothetical situation. Actually, this thing happened in the state of Bihar. The famous case known as Searchlight case. Anyone heard about this case, Searchlight? Anyone? Okay, I will give you another scenario. Suppose you are a government civil servant. You are a hardworking civil servant. After years of honest public service, one fine morning, you woke up to discover that a television channel and several social media handles uh, made allegations against you. And for your surprise, you didn't have any clue about that. And everybody started to comment on your profession, on your family. Okay, and it's not only affecting you personally, it's affecting your family, your career, your reputation. What would you do in such situations? The second case also, not a hypothetical situation. The thing very recently happened in the state of Kerala. A Malayalam leading channel published a news report against a judicial magistrate. So these two stories, though different in facts, raises the same questions. Where should we draw the line? Should the media have absolute freedom, like to publish anything, any kind of information they hold? They have the right to publish it, or the law should step in when a report that ruin someone's reputation or that affect national security. So today's session, we will explore we will explore why media laws are relevant in contemporary India. And especially we'll begin with the brief history of this constitutional mandate for free speech. From this free speech, the freedom of press actually evolved. So briefly, we will discuss about the history of this constitutional evolution. Then we'll discuss about various media laws in India and other laws that actually control the freedom of expression of the press. Okay. Then if we have the time, then if possible, we'll discuss about the right to privacy. I hope so. Media laws and their relevance. What would come to your mind when you hear these media laws? Anyone? What would come to your mind? Media laws and their relevance. Something to do with the newspaper. Okay, something to do with the newspaper. So media law, you viewing only through newspaper or any other media we are having? What are the other medias? We have newspaper, we have channels, now we have social medias, we have over the top OTT platforms, we have movies, everything media, mass media. Yes, news channel. Yeah, yes. So you all know a vibrant democracy work with freedom of speech and expression. And yeah, podcast, definitely. Now the podcast, different new medias evolving current times. Podcast, OTT platforms, Instagram reels, everything. Now it's like a mass media. So first of all, before starting the media laws, I have to give a brief introduction about our fundamental right. Yeah, YouTube short, correct. So what do you know about fundamental rights? Anyone? Fundamental rights. Have you heard about fundamental rights? You must be heard about fundamental rights. The Constitution of India guarantees to its citizen some special right, some special privilege. These are the fundamental right. Just like the US First Amendment, we have freedom of speech and expression, Article 19 of the Constitution. Article 19 of the Constitution ensure freedom of speech and expression, along with five other rights. Anyone knows what are these five other rights? The first one is we have freedom of speech and expression. Then we have right to peaceful assembly without arms. Then we have the right to form associations. Then we have the right to free movement throughout the country. We have the right to move throughout the country, and we have the right to reside and settle anywhere in the country. And the last one is right to profess or carry on any occupation or trade. These are the six set of fundamental rights guaranteed under Article 19 of the Constitution. Among this right, the most prominent, most important, just like the First Amendment of the US Constitution, we have Article 19(1)(a) of the Constitution. Article 19(1)(a) of the Constitution. So Article 19(1)(a) of the Constitution talks about right to freedom of speech and expression. So, I don't want to bring a lot of legal words and legal technicalities. So I would discuss this topic along with some case laws. So you can easily connect with the case laws. I think that would be more appropriate. So different case laws happen in our country. Okay, you all set? So freedom of speech and the press lay the foundation of all democratic organization. And the media or the press, we rightly described it as a fourth estate. Why it is called as fourth estate? Anyone? What are the other three important pillars of a government or a democracy? Legislature. Yeah, correct. Legislature. Then we have the executive. Then we have the judiciary. And along with these three bodies, we have as the fourth estate, we have the media. The democratic credential of a country or a state are judged by the extent of the freedom that country's media enjoys. On the basis of that country's press enjoy the freedom, on the basis of that, we can judge a country's democratic values. Is that, yeah, right to judiciary? Yes, yes, yes. So, just like the executive, legislature, judiciary, media is also an important component of our democratic society. Do we really have the absolute freedom to whatever we want to express, whatever? Suppose, just imagine you want to put some status in your WhatsApp, or you want to put some post on your Instagram. You have the absolute freedom to publish anything you want. Do you have? Okay, let's talk about a case. This case actually happened in 1950. Uh, a political journal called Crossroad. This particular magazine actually was based in state of Bombay. At that time, in 1950, we didn't have Maharashtra and Gujarat. At that time, we have a combined state of Bombay. So this Crossroad magazine actually published from Bombay and which circulated in the state of Madras. So what the government did is, some of the articles in that particular magazine become a challenge or started to challenge the ruling establishment. So the government of Tamil Nadu, at that time, we can say the government of the state of Madras actually prohibited, banned the circulation of this particular magazine in the state of Madras. The matter went to Supreme Court. The matter went to the Supreme Court, but the government stand was, on the basis of state security, the state has the whole authority to ban the circulation of the magazine. But the Supreme Court has held that freedom of speech include freedom of circulation and struck down the law that actually restricting the journal circulations. So this particular judgment for the first time established that press freedom is implicit in Article 19(1)(a) of the Constitution. That means Article 19(1)(a) explicitly talk about freedom of speech and expression. There is no mentioning about press freedom. You cannot see press freedom if you take the literal interpretation of Article 19(1)(a) of the Constitution. But this particular case, this case is known as Ramesh Thapar versus State of Madras. Ramesh Thapar versus State of Madras. I think it's not mentioned on the PPT. Ramesh Thapar versus State of Madras. This was the first case where the Supreme Court upheld, or the Supreme Court established Article 19(1)(a), the freedom of speech and expression implicitly included the right to press, the press freedom. Yeah, what is the question? Someone asking some question about the article? Somebody asking question? 19A. Okay, 19A. Article 19A of the Constitution, that's discuss about the freedom of speech and expression. Under this freedom of speech and expression, our press freedom also evolved, or the Supreme Court has given wider interpretation to freedom of speech and expression. Okay, we'll discuss. Step by step, we will discuss. Okay. So after this particular case, another case comes that happened around 1962. The case is known as Sakal Paper versus Union of India. Interestingly, this case was not actually related to anything published by a newspaper or a magazine. This was related to when the government started to regulate the number of pages of newspaper on the basis of the price they charged. So government logic was simple. They want to control the big media houses, large scale newspaper, and they want to protect the small newspapers. So what they did is, now government regulated maximum number of page a newspaper can publish. This was challenged again in the Supreme Court in this particular case, Sakal Papers versus Union of India. And the Supreme Court actually, in this case, another important point I just forgot to mention, actually the state government actually regulated the space for advertisement. So usually the newspaper, you will get a newspaper for 5 rupees or 6 rupees because they are earning more revenue through advertisement. So when the government started to regulate the advertisement for newspaper, like they fixed only limited page for the advertisement. So eventually what will happen? The price of newspaper will rise. So the Supreme Court held that by raising the price of newspaper, by restricting the pages for advertisement, which directly affect the freedom of speech and expression, because the freedom of speech and expression also include right to information. So if you want to form an opinion, if you want to talk about something, first what you need? You need information. Then only you can get a you can develop your opinion on the basis of the information. So the dissemination of information and right to receive information also comes under Article 19(1)(a) of the Constitution, and which also the Supreme Court linked with the press freedom. Are you following? You able to follow what I'm saying? So the reduction in the area of advertisement would reduce revenue and forcing them to raise the price of newspapers, which actually affect the newspaper circulation. So this directly affect the freedom of speech and expression. You can see how broadly Supreme Court is interpreting Article 19(1)(a) of the Constitution. Even though it's not directly related to freedom of speech and expression, it now linked the circulation of newspaper. The space for advertisement also comes under press freedom. Okay. Almost similar factual case happened around 1972. The case is known as Bennett Coleman versus Union of India. So in 1972, at that time, just before our national emergency, country was facing some shortage in indigenous newsprint. And at the same time, country was facing some shortage in foreign exchange. So the country was not able to import as much newsprint as per the requirement of the uh, magazines and newspapers. So what they did is they started to rationing, like they started to regulate the number of pages. Like they will tell to Times of India or Indian Express, you can publish only 5 pages, or you can publish only 6 pages. So this Bennett Coleman, he was the publisher of Times of India. He filed a case in Supreme Court under Article 32 of the Constitution because it violates its fundamental right guaranteed under Article 19(1)(a) of the Constitution. And the Supreme Court observed, actually, even though country is facing a newsprint shortage, the government do not have the power to reduce or dictate the number of pages a newspaper can publish or print, because it directly affects the freedom of speech and expression. Okay, so the press has the right of free publication and free circulation. Okay, and any restraint or any restriction on the publication of the on this Bennett Coleman cases, the Bennett Coleman versus Union of India, in this particular case, Supreme Court held the press freedom, the most important right guaranteed under Article 19(1)(a) of the Constitution, and the press freedom also include right to publish and right to circulation. An almost similar view taken in another case is known as Express newsprint case, and where the Supreme Court actually underscored the press importance in Indian democracy. Actually, the press act as a watchdog against any arbitrary state action. Okay, and finally, one of the major case comes very recently, not very recently, 10 years ago. Anyone heard about Shreya Singhal versus Union of India case? Anyone? Shreya Singhal versus Union of India. Anyone? Any idea about this case? Shreya Singhal versus Union of India. Okay, this case is a landmark judgment on online free speech. We have Information IT Act, we have Information Technology Act that usually regulate the like electronic media like communications. So there was a provision under IT Act, Section 66A. Section 66A means if you are posting something on your social media or if you are messaging to someone, that actually uh, someone can describe that as grossly offensive, inconvenience, or a menace, then the police can charge section 66A. Then the act would be a criminal act. You will be punished. Okay, at that time, one famous incident happened in Maharashtra. One of the prominent Maratha regional leader, I don't want to take their name, uh, he died. And when he died, a girl posted on her social media, today Mumbai is stopped not because of respect, but because of fear. A teenage girl, posted something like that on her social media, and the Mumbai police registered a case against the girl under Section 66A of the IT Act. Because if you are posting something on your social media, the Instagram, Facebook, or if you are messaging someone and someone consider that message or that post actually it's kind of offensive, then the police can register a case. This was challenged by this girl, Shreya Singhal, in the Shreya Singhal versus Union of India case. So Supreme Court looked into details of this particular section, Section 66A, and the language of Section 66A, which says anyone makes any comment like grossly abusive or offensive or causes inconvenience. What does it mean? These languages are vague. Anyone can be charged. Suppose you have enmity between any person, you can simply, if that person sends some message, some text message, you can file a case against him under Section 66A. So the Supreme Court has strike it down Section 66A by saying this particular section of IT Act is against or violative of Article 19(1)(a) of the Constitution that ensure freedom of speech and expression to the citizen of this country. So this particular section, Section 66A, that is a violative or unconstitutional provision. So they strike down the provisions. So the Shreya Singhal versus Union of India considered as a landmark judgment in the online freedom of speech and expression. Or now you can post something on your social media. You can comment on something. Okay. The Supreme Court has broadened the scope of Article 19(1)(a) through this case. And because of that, the online free speech actually got strengthened. So now you might be thinking, like the freedom of speech and expression is like the Supreme Court is more pro towards freedom of speech and expression and press freedom. You have this doubt like, do we enjoy the absolute freedom or the press freedom is absolute? The freedom of the media is absolute. What's your take on it? What's your take on it? Is freedom of the media or the press is absolute? No. Why not? The Supreme Court, even though the matter is not directly linked with any publication, they connected with the freedom of speech and expression. When the government started to regulate the number of pages, Supreme Court was a pro freedom of speech or freedom of press. Yeah, it is not absolute and unfettered. Why? An unrestricted freedom would amount to uncontrolled license and which could lead to disorder and anarchy. Why? Because the media wields enormous influence. A single news report which can shape public opinion and destroy a hard-earned reputation or even trigger a communal tension. So we don't have absolute right. These fundamental rights are not absolute, they are qualified right. What does it mean, qualified right? Qualified right, anyone? Qualified right means these rights are, yes, based on conditions. These rights are not absolute. They are subject to reasonable restrictions. Okay, they are subject to reasonable restriction. So Article 19 Clause 2 of the Constitution discuss about the reasonable restriction of freedom of speech and expression. The foremost one is security of the state. Suppose you are posting something that is actually against or that violate the security of the nation or the sovereignty and integrity of the country. You cannot post anything like that. You cannot claim that's my freedom of speech and expression. No, you cannot. Then it is subject to friendly relation of foreign country. That means suppose India having a friendly relation with United States of America or United Arab Emirates or Saudi Arabia. Somebody is posting something against that particular country and which actually causes diplomatic issue or that actually causes that caused our friendly relation with that country. No, you cannot post anything like that. That is subject to reasonable restriction and also public order, decency, morality, defamation, contempt of court. All these are reasonable restriction on your freedom of speech and expression. That also means your press freedom. That means your media freedom. You following? So here you have to remember, I mentioned about Ramesh Thapar case happened in state of Madras in 1950. At that time, actually, we didn't have this provision of public order and friendly relation. So at that time, we had only the security of the state, this contempt of court, decency and morality. Okay, but when the Supreme Court held a judgment against the government, what the government did is they brought the first constitutional amendment. Under this first constitutional amendment, they amended Article 19, Clause 2 of the Constitution. They added two more grounds: reasonable restriction, public order, and the friendly foreign relations. For your information, okay? Okay, is there any disconnection?
No,
Somebody's
sir.
commenting?
No,
Okay,
it's
okay.
fine.
Okay. So this reasonable restriction, on the basis of this reasonable restriction, the government brought various laws to regulate the media on the ground of these restrictions. Okay, so now you can let's see what are these various laws and different bodies to regulate the medias in India. The first among them is Press Council of India. Have you heard about Press Council of India? Anyone? Press Council of India. Press Council of India basically regulate the printing presses. That means the newspapers. Press Council of India. Okay. So that mainly focus on the quality of news that regulate the print media. That means the usual newspapers like the Hindu, the Express, Times Now, Hindustan Times. Okay. Then we have, so I will just briefly discuss about some particular laws. Okay. So the one is the Press Council of India. That's a regulatory body. Then we have Official Secrets Act. Official Secret Act means if you are a government servant or if you are spying on any government activity and you are sharing that communication, that secret information to someone else, then the government can charge you under the Official Secrets Act. So if you are a media person, or if you are a journalist, or if you are a content creator, and you are doing content on this any government restricted information, then the government can initiate legal action against you. Then we have Defense Act. This Defense Act is actually enacted during the Indo-China war time in 1962. So at that time, when we are having a war with another country, the government, the union government enjoy the sweeping power to censor the press. They can control the press. They can restrict what they publish. Okay. And interestingly, an interesting story comes during the time of Indira Gandhi, the emergency. Uh, During the opening session, ma'am was mentioning about the emergency and the freedom of speech and expression. So during that time, there was an officer. So every newspaper, before publishing their newspaper, they have to submit a copy of their newspaper to this particular officer, and he will approve. Then only the newspaper can publish their news. Think about such situation. This actually happened during 1975, during national emergency. Because at that time, we have a provision under the constitution, emergency provision. During emergency, Article 19 automatically gets suspended. So at that time, Indian Express, they actually protested against this censorship. Yeah, yes. They protested against this censorship by simply publishing their newspaper blank. Blank newspaper. So when the Janata Party came into power after Indira Gandhi lost the election, these people, they were the major victim of national emergency. They amended the major provisions of constitution, and now currently for internal emergency, the Article 19 is not automatically dissolved. Now, if national emergency is declared on the basis of external emergency, that means because of war, then only Article 19, freedom of speech and expression, can be restricted. Okay, just for your information. Then another major important act is IT Act. IT Act. IT Act is basically governing the electronic communication. So mostly our electronic communication, the social medias, Instagram. That means the Instagram, or if you are using mail, uh, YouTube, uh, everything governed by this IT Act 2000. So that's already we discussed. At section 66A of IT Act was now strike it down. Now there is no section 66A, but still there are many other provisions, many other sections that can regulate the electronic media. And now, other than this television and newsprint, currently we are having over the top platforms like we have Netflix, we have Amazon. Like we need only a internet connection, and they will give you whatever content you want: movies, documentaries, cartoons, whatever. So to regulate this OTT platform, the government amended the IT Act and they brought IT intermediary guidelines, digital media ethics code rules in 2021. So this particular uh, guideline focus on to make social media platform and intermediaries more accountable for their content hosted on their platform, and intermediaries to exercise due diligence in removing unlawful content when legally required. And they have to establish a grievance redressal mechanism for users. These are the major provisions of. Okay, so now currently we are having we are regulating these OTT services, cable TVs, news channels, newspapers, And another major weapon of the common man is actually the provisions of defamation. What is defamation? Defamation is one of the most important restriction on the right to freedom of speech and expression. So that means making or publishing a false statement that harms the reputation of another person. Just imagine your hard-earned reputation. So today's social media time, it can be destroyed within seconds with one single click. Someone can post something, anything against you. Someone can share some post against you. That can ruin your career. That can ruin your family life. Okay. So here you have to understand defamation is a criminal offense. That means under Article 19(1)(a) of the Constitution guarantees freedom of speech and expression. Article 19 Clause 2 gives reasonable restriction, and this reasonable restriction includes defamation. To protect individuals, especially the common man in this country, under Indian Penal Code, we had a section 499 and 500 IPC, which criminalize the defamation. If anyone publishes anything, publishes means anyone speaks, anyone writes, or if even through the media, through the medias of cartoon, any other medias like movies, any defamatory statement is a criminal offense. If you feel like your reputation is targeted, you can file a case, you can petition. And currently, the Indian Penal Code is actually now changed. Now we have Bharatiya Nyaya Samhita. Under this Bharatiya Nyaya Samhita, section 356, which criminalized defamation. Here you have to understand, for this particular thing, there is civil remedy also available. Civil remedy means you can approach a civil court for compensation. If your reputation is, someone is trying to ruin your reputation, you can file a civil petition, civil suit in a civil court for compensation. So if you are working, or even if you are making any content in online platform, you have to remember defamation is a criminal offense. So this particular defamation provision was challenged in Supreme Court, challenged by a famous politician in India who is quite famous for making controversial statements. Anyone heard about Subramaniam Swamy? Dr. Subramaniam Swamy. He challenged the section 499 and 500 of IPC in Supreme Court by saying this particular section actually violates freedom of speech and expression, because Article 19 guarantees freedom of speech and expression, but someone fear, like someone cannot express himself without fear, then that is the violation of Article 19. That was his argument in Supreme Court. But Supreme Court has said, in today's time, especially because of the social media, one's hard-earned reputation cannot be compromised. Okay. And Supreme Court upheld the validity of section 499 and 500 IPC. And this case is known as Subramaniam Swamy versus Union of India. It's a 2016 case. And another major important matter comes from the thing I initially mentioned, the parliamentary privileges. The Bihar case, I mentioned about Searchlight case. In that particular case, a media person reported what actually happened in the state assembly. But the speaker actually wanted to remove that particular portion from the assembly records. But this person published it. So you have to remember, under the Constitution, Article 194 and 104, it is protected. Special privilege is given to assemblies and houses. Houses means parliament, Lok Sabha and Rajya Sabha, state legislative assembly and state legislative councils. So they have special privilege, and you cannot claim freedom of speech and expression by defaming or by breaching the privilege of the houses. A interesting case happened in Karnataka, where two journalists got arrested for reporting some defamatory statement against some MLAs and speaker. So here comes a conflict like freedom of speech and expression and the privilege of the House. So more oftenly, the court approach a balanced approach. Yeah, so we were discussing about the various media laws. Now you have to remember right to privacy. This particular notion comes from under Article 21 of the Constitution, and the Article 21 which explicitly talks about right to life and liberty, but the Supreme Court has given wider interpretation to Article 21 of the Constitution. So in a very recent case, Justice Puttaswamy case, in that particular case, Supreme Court has declared right to privacy is a fundamental right guaranteed under Article 21 of the Constitution. So your right to privacy is a fundamental right which is protected under Article 21 of the Constitution. So after this particular judgment, the government of India appointed a committee. The committee is known as Sri Krishna Committee. B.N. Sri Krishna, he was a former Supreme Court judge, to make laws related to digital personal data protection. That means right to privacy means today's time we share almost everything in our mobile or in our digital devices, our personal contacts, our photos, our sensitive information, even our locations. Everything we share with the different apps. So the Sri Krishna committee that recommended we have to a proper digital personal data protection law. For that, the data collection restriction, like there must be some restriction on what kind of data a software company or a app can collect, or a data protection authority. And there must be a explicit consent required. That means whenever you are downloading Instagram or any new app, they ask for some agreement, some consent, that terms and conditions. We never read that. We simply agree with it. And we don't know what kind of information they are taking. You know, all your personal information maybe they are taking. Your contacts, your access to your camera, maybe access to your gallery. So here, the committee recommend explicit consent requirement. Similarly, right to forgotten was another major recommendation given by the Sri Krishna committee. Right to forgotten means sometimes you might have posted something years ago, or maybe some of your personal videos may be posted someone in online platform. So right to forgotten means you can approach the court to erase that particular content from online platforms. That is right to be forgotten. Then data localization. Data localization means the different companies, the foreign countries, they have to keep the information within the boundaries of this country. These were the major recommendations of the Sri Krishna Committee. And on the basis of the Sri Krishna Committee, we have almost most of these recommendations we accepted and we enacted a Digital Personal Data Protection Act. And another major important thing you have to keep in mind, especially when you are working in journalism or in content making, you have to remember copyright laws. Media professional must respect intellectual property rights. Using someone else's content or images, audio, videos without permission actually led to legal actions. So here you can understand the legal landscape of media is complex and constantly evolving. A journalist who does not understand defamation law might publish some statement which lands their organization in a costly lawsuit. Similarly, a reporter unaware of privacy protection might use surveillance technique that violate the law. A digital content creator who ignore copyright that also might face serious legal consequences. So you have to keep in mind, we don't have a clear-cut comprehensive law related to media. We have different laws. IPC, we have constitutional provision, we have IT Act, we have defamation, uh, we have intermediary regulatory acts, we have copyright acts. So all these laws actually regulate the press or media. So the blurring of lines between news and entertainment and the increasingly sophistication of misinformation campaign all demand regulatory mechanism that must be more agile, more informed and right respecting. So, in my view, we have to bring a more comprehensive, robust framework that can adapt to rapid technological change without sacrificing the core principles of press freedom, accountability, and public interest. I think for that, we need a collaboration between the government, media organization, civil society, and the tech company, and most of all, the informed citizens.
So, sir, shall we begin with a question from our side?
Yeah, sure.
Last decade, 550 journalists were killed around the world. Despite strong media laws, why are media professionals dealt with by violence, weakening democracy?
Yes, kind of. Especially, Whistleblowers Protection Act. The government is planning to bring a more comprehensive Whistleblowers Protection Act. So thereby we can at least protect the news reporters. They mostly work in very, you know, uh, very disadvantageous. They report and they work in very disadvantageous positions. Like I can give you some examples. The states like Bihar, Odisha, Uttar Pradesh, and some mining states where the local reporters they publish stories about these illegal mining activities. Many of these journalists uh, had to face a lot of consequences. Mostly, many of them lost their life, or at least they attacked by gundas. So it's a kind of, in our country's perspective, journalist protection is need of the time actually. We have to bring a comprehensive special laws to protect journalists, especially to promote free journalism. So, the privilege. I'm not uh, I'm not accusing anything or anyone, but the privileged journalist, mostly the channel reporters or the someone who make the debates, they never get these kinds of threats. In Indian perspective or in Indian situation, mostly the local reporters, they report about the illegal sand mining or illegal coal mining, or they expose some public distribution scam. They get targeted. So we have to bring a comprehensive law that protect every journalist in this country. And for that, I think more than a law, we have to make people aware about their own rights and what are the legal remedy they can approach the court if someone is threatening them. And we have to bring more sophisticated and we have to bring more, I could say, like law enforcement agencies. Then only we can say like uh, the journalism without fear, someone can work.
Yes, sir. Yeah. So, sir, in that case, do you think that recent measures by the government, such as pressure and press and registration of periodicals Act 2023, Broadcasting
Yes,
Regulation Service Bill, and Digital Personal Data Protection Act 2023 hampers the press freedom?
it's it's about the perspective. So someone may see this as encroachment upon the press freedom and freedom of speech and expression. But another angle is the government. That is the most powerful authority that regulate every citizen, every action in the country. They have to get proper information about whatever organizations, whatever media houses actually operating in the country. They have to get information. And if they are receiving any kind of fund from any foreign countries, or if because there was a case very recently happened, and that case actually a reputed, I don't want to take their names, reputed editor in chief, he got arrested. He was put under custody, and the allegation was he took some money from some Chinese firms. We don't know about the uh, relevance, and we don't know the correctness of the allegations, but still the allegation was that this particular editor in chief took money from a Chinese firm and tried to make some law and order situation in the country. Similar was the allegations against one of the renowned international organization that tried to sabotage the Kudamkulam nuclear power station. So from government point of view, they want to ensure, they want to bring more governance in their sphere, but somehow they are afraid of, or we can say, they are kind of apprehensive about the foreign organizations involving in the country's internal affairs. So for that, the government side, government version is the foreign organizations actually uses Indian media's Indian organizations. That's why they are tightening the control, like making the registration. They are controlling the foreign contribution, FCRA regulations, the NGOs regulations, everything coming just like that. But as a uh, practicing lawyer and someone who believe in the constitution, uh, my personal opinion is, it's somehow actually it's encouraging the people's freedom of speech and expression, especially the journalism, especially the media, and we can feel the difference. Like somehow, uh, s- even some people, I don't want to. Okay, I don't want to make it a political statement because we are in a public platform. Okay, this is how the current situation. Okay, okay.
Okay, sir. Sir, we have a question from Suma Vargas. When we use audios or videos or pictures for school presentation or programs or flip lessons, how do we ensure we are not infringing on copyrights?
That's a good question. But actually, if you are not taking from someone's post, or more, the Copyright Act, copyright law applicable only when someone is registered their product, like their post or anything. Then only the copyright will law come into play. If someone is not claiming, if someone is saying like my articles or my products, whatever, it's free to use. You can use it, anyone can use it, but someone already posted something, and you know you are stealing that post, you know that you are stealing that post, and that person came to know about using that particular post by you, then he can send a legal notice to you. So it's all about most of the copyrighted product would not be available freely in any Google space, because intellectual property laws are very strict. So even they have to face the legal consequences, the intermediaries, if it is freely available.
Okay, sir. Sir, there's another question from Anjali. How can schools promote responsible digital citizenship among students while respecting freedom of expression?
Yes. First of all, we have to teach the students the fundamental rights like Article 19 of the Constitution. First, they have to know about what are their rights. What is the Constitution guarantees to them? The freedom of speech and expression, along with reasonable restriction. What are the reasonable restriction? Nobody can claim I have absolute freedom. My freedom is till I'm touching someone, or I can stand with someone, but I cannot slap that person. Same with your expression also. You have freedom of speech and expression doesn't mean you have the right to say or post whatever you want. So we have to bring more responsible citizen. We have to teach them our constitution. Then we have to make sure they are aware about the digital laws, especially the privacy, right to privacy. So especially when in schools, we have to teach them uh, the consent they are giving to different apps, or they are downloading, they are installing different apps. First, they have to make sure that genuine apps, and they have to make sure what kind of information. Now it's available because it's now legal mandatory. Every apps, every software, they have to give this information, what kind of information they are taking from you, from your phones. So we have to make sure our children, our students, they must be aware about this digital platforms. And because, many people, uh, even many cases come before me, many people now uses some instant loan applications. And most of these loan applications, these platforms, actually not approved by RBI. And because of this loan app, like it's very instant loan. When you apply for it, you will get the money instantly. And you will think like, okay, it's a small amount. I will take 5,000 or 10,000 instantly. I can pay back. But you don't know you are giving permission to what like features. They are maybe getting access into your camera. They are getting access to into your sensitive information, your personal photos. And at one point, you realize if you are giving permission to that particular app, one point you will realize they actually use like threatening, like they will expose you, or they will say they will they have your contacts, and they will send some morphed pics to them if you are paying this much money, or if you are not paying this interest. So you have to make sure, you have to understand your children's, they must use social medias, any apps responsibly. And when they post their picture on social media, that may also misuse it by someone, especially in Telegram, Instagram, especially child pics. So recently, many cases going on when someone posts and they make their accounts public. Anyone can see that pics. Anyone can download that pics. Anyone can screenshot that pics. But you have to remember, you have legal remedies. You have to file cases if someone is misusing your account, your profile, or anything. So we have to make sure our children must have awareness about these things. So we must teach them responsible usage of social media. Okay. Yeah. What is the question? Someone
Yes,
asking
there's one
something.
more question from Sarita. Is it must for schools to get the consent from parents to post the child's picture in social media and even in WhatsApp status?
There is no law uh, dictating like that. But if someone posted some pics in social media and somebody misused it, then the POSCO Act, like Protection of Children from Sexual Abuse, POXO can be bring against the person who posted. Like if someone misused that particular pic. But prima facie, we cannot say a innocent, a normal pic, a ordinary pic, someone posting. There is any harm in on that. But you
Thank
have
you
to
so much.
remember when you deal with the children, you have to be very careful. There are many laws to protect the children. Without, especially when you are dealing the children without the parents' consent. So if the parents move illegally, there are a lot of complications. So you have to keep in mind that.